there are aspects of it where the things are a little different now because we're in the Trump administration, and I'll point that out as well as I go through the PowerPoint. All right. I'm going to pull the PowerPoint up. So this is in the materials.
Professor
Yeah,
Professor Liebmann, one question,
of
just to let
course.
everyone know, this is being recorded, and we are going to be using it if as we follow. We are going to be using this recording, but just want to let you all know that this is recorded. Thank you.
Terrific. Okay. So here's the slides. And you guys have these in your materials. So they can be distributed. You can take notes on it, etc. But I'm going to be going through these. The other two sets of materials that I provided, one is a guide to guardianship proceedings in family court, and you'll see why shortly. And then the third one is just a list of case law in New York that relates to both guardianship and SIJS type proceedings. And it's just useful to have. So I'll mention that along the way as well. Okay, so there we go. Yeah, so let's talk first about sort of the background of SIJ. So as I said, it was a piece of compassionate legislation, bipartisan, if you can imagine that, all the way back in 1990. And actually, the impetus for special immigrant juvenile status started in the late 1980s. And the reason that there was this movement was because there were many children who were in the foster care system who were aging out of the foster care system but did not have lawful immigration status in the country. And so there was a caseworker in California who essentially thought that as a government agency that was responsible for the care of children in foster care, how could they feel that they were doing an adequate job if the children in their care were leaving foster care without lawful immigration status, couldn't get a legal job, couldn't get access to higher education, constant risk of being deported. And so this caseworker basically worked with uh, Zoe Lofgren, who at the time was a congressional aide, but is now a House member from California. And they teamed up and they got this law passed. Now, there have been a couple of tweaks since then, but the basic idea is the same, which is that this is a form of compassionate humanitarian relief for children who have been abused or neglected or abandoned, and for whom it would not be in their best interest to return to their home country. And so that essential idea has stayed with it since 1990, although there have been certain tweaks. So um, let me go through that's a little bit of the background now. Now, in terms of the overall pathway, and we're going to zoom in on mostly the family court part of this, but the overall pathway to use SIJ to be able to get lawful permanent residence starts actually in a state family court. And part of the reason that these SIJ cases, I mean, the immigration system is Kafkaesque by itself. But part of the reason these cases are Kafkaesque on steroids, I guess, is that it involves working in the family court, which is a state court, not a federal court, a state court. It involves working with the immigration agency, USCIS, which processes applications. And if the young person that you're helping also is in removal proceedings, it involves immigration court as well. So you have typically, and I would say most of the time, you have three different arenas where you have to be working to help a young person to eventually get SIJ. But as I said before, the meat of it, the real heart of it, happens in the state family court. And so what one has to do in order to follow this pathway is you have to get into family court, which means initiating a family court matter. I'm going to be speaking more about that. This is just an overview here. In the state family court, you get something called special findings. You might also hear it referred to as SIJS findings or predicate findings. Um, when you get those findings, and I'm going to talk about what those are, when you get those findings, those are the basis that you can use to apply to USCIS, which is the United States Citizenship and Immigration Services. It's the immigration agency. You can use it to apply to them to get SIJ status, Special Immigrant Juvenile Status. When it's approved, then that can be the basis to apply for a green card, to apply for lawful permanent residence. Now, right now, so you have to wait for a visa date to become for your turn, basically, to get a visa, to apply for that green card at the end there. And right now, that date is unknown. Usually they give you a date, but right now they have a U there. They're going to have the date there eventually. Don't worry about that because if you get special immigrant juvenile status while the person is still young, they can hold on to that until it's basically their turn to apply for lawful permanent residence. Okay. Now, this second box from the bottom here where it talks about you can get a grant of deferred action and file an I-765. So this is one of the things that the Trump administration has essentially done away with. In the Biden administration, they created this possibility so that once you were approved for SIJ status by USCIS, you had an opportunity to apply for a work permit while you were waiting the years to be able to apply for a green card. And deferred action, which means you're not going to be someone, it's like the Dreamers, you're not going to be someone that we're targeting. That's what the deferred action does. And it allowed you to get a work permit, which allowed our clients to work with authorization. It allowed them to get funding for higher education, et cetera. So just one of the many cruel things that you don't see in the press that Trump has done, but has a huge effect on individuals. Robbie mentioned another one, which is the cut in funding for unaccompanied children, although that has been enjoined for now. So some of that funding is going back, but just the uncertainty for those organizations, they're not going to have the same kind of capacity that they once did. So there's litigation on this, on some of these things, but this is the basic pathway now. And those first three pieces, family court, you get those findings, and then you apply to USCIS to get SIJ status. Those all are the same, and no changes in that. Okay. That was probably more than you needed to know on that piece of it, but I think it's good to know a little bit of the background on some of that. So let's go now to what we have to do in family court. What we're trying to get from the family court, again, are these things called special findings or SIJ findings, predicate findings. You'll hear them referred to in different ways by different judges and in different courts. But these are findings that we have to get in a state family court under the statute. So the five findings are that the young person is under 21, they're unmarried, they're either declared dependent on a juvenile court or committed to or in the custody of a state agency or individual appointed by the juvenile court. There must be a finding that reunification of the child with either one or both of their parents isn't viable due to abuse, neglect, abandonment, or a similar basis found under state law. And there must be a finding, again, all by the family court, that it's not in the young person's best interest to be returned to their country of nationality or last habitual residence. Those are the key findings that you want to get. I'm going to drill down into each of them in just a little bit so that we understand sort of what each of those mean and also how to get them. Those findings can only come from the state family court. Very important to remember that what the family court doing is not granting special immigrant juvenile status. It's making findings. And these findings you can use to apply with USCIS for special immigrant juvenile status. Um, it's important to remember that. I will tell you that there are judges who would still all the time, when they make those findings, say, congratulations, I've just granted you SIJ status. They are not granting SIJ status. It's important because we do not want the federal government to think that we are getting um, findings from a state court that are federal in the federal government bailiwick. That's their responsibility to do, which we aren't, but you don't want language in there from a judge indicating that. Okay. So getting those special findings. Uh, First, if you're meeting with a young person or a young person and their guardian or their parent or whatever it is, you'll want to determine whether they're eligible for SIJ. And it's those 5 findings again that determine their eligibility. So if you're meeting with a young person for the first time, are they under 21? Are they unmarried? Um, are they living with someone who can be appointed as their guardian, right? Because that would meet this third one here. Has one of their parents or both of their parents been involved in behavior that's abusive or neglectful, or did their parents abandon them? We'll talk about that a little bit. And can we show that the young person it's not going to be in their best interest to return to their country of origin? Okay, so obviously this kind of stuff, in terms of when you're meeting with a young person who you want to see if you can help them, obviously the first couple are easy enough to find out. How old are you? Can we see your birth certificate? Are you married? No. Are you living with someone who can be your guardian? Okay, that's sort of the first 3. But then you have to start asking some questions about their parents and how they've been treated by their parents. And when was the last time they saw one or both of their parents, and things like that. So it's a good thing to get some training on in terms of working with young people, engaging in interviews with young people, being trauma informed, and those kinds of things. That's not this training, but it's a good training to have. If you think about it, if this person is meeting you for the first time, there's a decent chance that they're not going to want to tell you about some of the worst parts of their life. That might not be something that they want to do. So there are techniques to that. And obviously, same for the best interest. For the most part, our clients are coming here because they're trying to get away from something that was really difficult: extreme poverty, abuse from a parent, community violence, those kinds of things. Very rarely are these extremely dangerous journeys that our clients undertake done for anything other than some sort of desperation. So there's almost always reasons for that last finding. Okay. So determine if they're eligible, then you get these family court orders. And then, and Robbie, I don't know, how much you're connected with lawyers to handle the part once you have the findings, but you want to be connected with someone who can take those findings that you get from family court and do something with them. Because if you just get those findings in family court, honestly, you have not helped that young person at all. Those findings are meaningless unless you actually use them to apply with USCIS for special immigrant juvenile status. Okay. All right. So how the heck do we do this? Let's go through the procedure. The first thing you're going to do is you have to file a case in family court over which the family court has jurisdiction. And for the most part, we do those through guardianship cases. I do just want to mention that that's not the only type of case where you can get those kinds of findings in family court. So just for example, there's a type of case, maybe I don't know how many people on who are on the Zoom might know this, but there's a type of case, a Family Court Act Article 10 case, which is a child abuse and neglect case. So if Child Protection Services has filed a case alleging that a parent or someone else has abused or neglected a child, that's a different kind of case, but you can get findings, special findings in that kind of case too. The reason that primarily we do it in guardianship is for the most part, the young people we're helping do not already have cases in family court. And so we have to get them into family court. And the way we do that is that we help them petition to have their caretaker appointed as their guardian. Um, it can also be, you know, in terms of caretaker, that can be the person who they go to for advice and assistance. It can be the person they're living with who financially supports them, etc. But that person who's the guardian is going to need to be on board with all of this because they're going to be involved in the family court proceedings. After that, they're not involved. They're not involved in any of the immigration stuff, but they do have to be involved in this piece of it. So a young person comes to you, they can be living with one of their parents, just not both, living with one of their parents, living with an aunt or an uncle, or someone who has, I mean, we have cases where, you know, the young person was shopping and someone heard their accent and said, "Oh, you're from the same part of Guatemala as I am." And the young person was like, "Oh, that's wonderful." And then the other person like, where are you staying? Well, I'm not really staying anywhere right now. Well, come stay with me. So really just beautiful stories in many ways. And sometimes it's an older sibling or things like that. So we have to get into court by filing these guardianship petitions. And if the young person is 14 or over, they can be the petitioner. They can be the person who says, "Hey, court, I want my uncle appointed as my guardian." Okay. If the young person is under 14, then the proposed guardian has to be the petitioner. Okay. "Hey, court, I want to be my niece's guardian." Um, and so that petition is a part of the application. Um, what I've you can see the asterisks here on this slide. Templates are available at newyorkcourts.gov. If you Google New York court guardianship forms family court, you'll get that as well. They have a fillable form. They have a word perfect form if you need to sort of make some adjustments. So it gives you basically what the courts are expecting. I will say that at our clinic, we don't use those templates because they're full of really excess legalese in them. And we generally try and use plainer language when we can. So we don't use those, but that is a great baseline to go to. Go to those forms. You can adapt them a little if you want. If you are going to adapt it, definitely talk to a lawyer, you know, and make sure a lawyer with some experience doing that, and make sure you're not adapting it and taking out something that actually has to be in there. But that's a great place to get all of these forms and give you a basic. The second form that I have there, the oath of the guardian, is essentially the guardian saying, "Yeah, I want to be the guardian, and here's an address where I can be served with papers." By the way, I should point out that there isn't always logic to this stuff. It's good to have your logic caps on, but it's also good to remember that some of this stuff has no logic. So, for example, if the guardianship petition, if the uncle is saying, "Hey, I want to be the guardian," why do they also need an oath saying, "Yeah, I really do want to be the guardian"? It doesn't make any sense. But some of these things are anachronistic, and um, uh, you know, I suppose one could battle it, but for most of our clients, this isn't the kind of thing they want us to battle, whether or not to fill out. This Form 6.2 is a one-page thing that's really easy to fill out. It's not a battle our clients want us to fight. They just want to be able to get immigration relief. The third one is the consent or preference of a child. So if the young person you're helping is between 14 and 18, they have to indicate a preference. Okay. The idea is that once they're over 14, the court needs to know their preference. but doesn't have to follow it. Okay. Once they turn 18, so if they're 18, 19, or 20 and filing this, they have to sign the consent. It's the same form, one, but you just cross, you adapt it to say consent or preference because they have to, once they turn 18, they could just walk out of the home if they wanted. And so they have to consent to having the person as the guardian. And so that form gets filled out. There's another one where you can see the logic. If you have an 18-year-old who's filed the petition to have someone appointed as their guardian, it makes no sense that they also have to sign a consent. But, we do it. Again, it's an easy form to complete. The parental waiver, most of the time we don't have that because most of the time our clients are um, the parent that they're not living with, that they're saying abused, neglected, or abandoned them is either going to be too hard to find or not going to be willing to consent. And if they're living with the parent, usually that parent we would ask that parent be the guardian, which I should point out is something we often do. So if a young person is living with the one parent, but the other parent is the one who abused, neglected, or abandoned them, that child is eligible for SIJS and special findings. Okay. What the guardianship petition would be, I'm this child's mother. I am asking to be appointed as the sole guardian of the child. And actually, that can help that parent in many ways because it makes it easier for them to be able to get a passport, for example, for the child without needing the consent of the other parent, register them for school. It helps with a lot of things to have that order. Oh gosh, the second to last one here, the OCFS 3909. That one's the worst, right, Robbie? That's that form. Um, Essentially, you list everyone who lives in the household, and then for anyone 18 or over in the household, you have to list their addresses by month, with precise months for the past 28 years. Yeah. I don't know, Jill, for some reason your face is up on my screen, but yeah, that's exactly my reaction. So um yeah, that's it's it's nutty. So a couple of things about that. One is in terms of the definition of the household, it's members of the household. So sometimes this comes up, some of our clients are living in homes with lots of people living in them. And there's this question of, well, they hardly know seven of the people who are living in this house. Do we really have to get the past 28 years of addresses for those seven people? So it is worth asking some more information. Are you and the child in this case, do you live in a separate room? Yes. Does it have a lock? Yes. How often do you all eat meals together? Oh, we never eat meals together. You can 100% make a good faith argument. Those people are not members of the same household, and so you don't have to list them on the form. So a little investigation to find out, is this the kind of person? And by the way, the form doesn't tell you exactly how to decide if someone's in the same household. But what you want is if someone says, well, those people are in that same building as you or in that same house as you, what do you mean they're not in the same household? That person or a lawyer who's with them will have a good faith argument to say, yeah, but those people, they're essentially strangers. They're all in separate doors, etc. Okay. And then the last thing is a birth certificate with a certified translation that you should include. Okay, so these are the essential documents. Again, if you go to newyorkcourts.gov, you can see some of the forms. Okay. So what happens after the case gets filed in family court? It varies. This is one of those situations where it varies court by court. I'm mostly practicing in Long Island where, Nassau, we submit this and then we wait for them to give us a court date. In Suffolk, it's a little bit different. We have to submit this plus our request for the special findings all at the same time. And, the New York City courts are a little bit different too. But this is a general outline of what you can expect, or really what the people you're helping can expect once they get into court. So one is that there is a requirement, a due process requirement, apparently still exists. So a due process requirement that if someone is asking to be appointed as the guardian, or if the young person is asking for someone to be appointed as the guardian, the parents or parent, if one of the parents is going to be the guardian, right, is entitled to notice of someone saying, "Hey, I'm going to be the guardian." And so there are certain service requirements. For those of you who like to look up statutes, the service statutes are Circuit Court Procedure Act 1705, and then the CPLR provisions that are here. So what I can tell you is this in terms of service. If a parent has abandoned a child, service is not required on them. So an argument can be made to the judge, Your Honor, don't make me serve the parents or parent because they abandoned my client. And you can do that through a motion, which is the best practices way to do it. Obviously, an attorney would need to do that, but it can be done that way. Uh, and also, when you dive into these provisions a little bit, you'll see that it's okay to serve a parent who's out of state at their last known address. Okay, so that's also helpful. Usually there is, unless was abandonment at a very young age, there is some memory of like the last address I lived at when my father or mother was still there. And so that can be helpful as well. Also, that happens after the filing, a criminal history check. So grain of salt on this one, which is that there is really good case law that says that the family courts are not allowed to require the criminal history check with fingerprinting, which is how they do it, as a condition of going to a hearing in these guardianship cases. They're not allowed to. So that does not stop many of the judges from still saying, I need a fingerprint check. If that happens and you're working with the young person through that, that is a decision that your client and your client's family, their proposed guardian has to make, right? Do they want to just comply and go do the fingerprinting, which they'll do in the courts? Or do they want to push back and say you're not allowed to require this? And I always leave that up to my clients. I tell them, if you want us to push back and the judge rules against us and we appeal, we will win the appeal, but it will take 9 to 12 months to do that. And often our clients and the people who have to be fingerprinted in the home, which is anyone 18 or over in the household, just say, you know what, we'll just do the fingerprinting, which I understand, but it still burns me up that they get sort of cornered into doing that when judges aren't supposed to require that. I think the city has gotten a lot better. Some of the judges out here on Long Island are a little bit better than they used to on that. So often you don't need to get fingerprinting and fight that battle anymore. The OCFS check, that horrible form that I talked about, is checking for any history of child abuse or neglect. So it will go up to the state central registry in Albany, and any report that's been called in against anyone 18 or over in the home will pop up. So again, if you're going to be working with with your client a little bit longer term, it is worth finding out, has Child Protection Services ever been to the home? Even if there's been a Child Protection Services report, that does not mean you can't get guardianship or special findings or anything, but it's information you'll want so you'll know how to address it with the court, because the court is going to find out about it. And so you want to be able to understand how to address it. Post-filing issues. Oh, most of the courts don't order a Department of Social Service or CPS or ACS investigation. But sometimes they will, but it's rare. It's really if they get any inkling that the proposed guardian is somehow mistreating the child, then they might order a CPS or an ACS investigation, but it's not done as much. And foreign language documents I just put in there because that's a provision that explains what documents you need to translate, but it's essentially government documents like a birth certificate. All right. Yeah, this is so this is what I think of as the fun part, which is what happens when you're in court. Judges do this a little differently, and I list here the kinds of things that, our clients should be ready for, and if we're going to be representing them in court as well, what we need to be ready to be doing, for those of you who are lawyers and might be heading out to do this. Um, so first, we want to present in written motions with legal memos, citing the case law, why our client meets each of those five findings. Now, a couple of those are purely factual, right? Under 21, here's the birth certificate. Unmarried, here's my client's affidavit. And look, paragraph 3 says, I'm not married. Okay. And some of them are going to require some legal argument. We're saying that reunification isn't viable because my client's parents neglected her. We can't just say that. You have to say, well, what did they do that was neglectful? Okay. I'll give you a short list in just a little bit, but that's where, the lawyers earn their keep. Here's the case law. Here's our claim. Here's how this case law applies to our facts. Therefore, there was neglect, etc. And many of the judges will require testimony on that. Some of them will rule on the papers. Um, I like to think strategically about that. If I'm working with a client where I think testimony is it's a close call, but the testimony will push it over the edge, because of how powerful my client's story is, etc. I'll do that. If I have a judge who I can tell because I know is going to grant it, rather than make my client talk yet again about these traumatic experiences, I'll say, sure, you can rule on the papers if that's what they want to do, but you have to sort of play that by ear a little bit. And you certainly, whoever's going to be going to court with them wants them prepared to testify, because they are going to have to. There's a good chance that they'll have to do that, and they definitely should be prepared. Okay. All right, let me go through sort of each of these findings just to drill down just a little bit. Under 21, so the under 21 means, remember I said you get these findings in family court, but they're useless unless you actually send them to USCIS with a completed application form, which is called the I-360. So um, the reason they're useless if you don't do that is because one, USCIS is the agency that determines SIJS status, but also if you don't get it to USCIS before your client turns 21, they're no longer eligible. It doesn't matter. You could have gotten it for them when they were 14. But if you don't file that SIJ application and it isn't received by USCIS before your client's 21, they've lost that opportunity. Don't let that happen. I, I I can count on just, I think, the one hand the number of times, but that's still too many. I've gotten a call from a lawyer who said, like, hey, I just want to know, I got this for them, 6 months ago, but they're 21 now. So what do I have to do? It's like, there's nothing to do. You're done. You missed the opportunity to do it. So um, anyway, so that's why it's important if to link them up or connect with someone who can complete that I-360 form, and get that filed. Okay. Yeah. Oh, I put this other paragraph in here because sometimes judges will really push back and say, your client's 20. Why? They're over 18. They've reached the age of majority. They're not 21. Why are we having a guardian point? Why did you come into court so late? And so sometimes it's because our clients, don't get to this country, until they're over 18, et cetera. But sometimes I've had clients who've been here since they were 2 or 3 and come to our office at 19 or 20 because all of a sudden they were like, oh, good, I'm ready to apply to college now, and realize that they don't have lawful immigration status and that what an issue that's going to be. So sometimes it can happen that way too. Okay. So that's under 21. Unmarried. Unmarried at the time the SIJS petition is filed. Yeah, it used to be that they had to stay unmarried until they actually got the green card, which was brutal. I had clients who, met the loves of their lives. They wanted to get married, but because of the wait list, they couldn't get married without losing their pathway to lawful permanent residence. And then the other points I just sort of make here are that sometimes when you're meeting with the client, they'll say, "Yeah, no, I am married." Dig a little deeper. When you say you're married, was this, was this a marriage that was um, an officially recognized marriage? How old were you when you got married? So it may be a marriage that's not what would be deemed a legal marriage here, and therefore would not count as being married. Um, I wrote here who have annulled marriages or who are divorced, marry and get divorced are eligible. That is true, but I certainly would be that would be a challenge, I think, in this administration, which is looking for any reason to deny any kind of application. But I'm not saying it's impossible. Dependency on the juvenile court. So um, that can mean placed in the custody of the state or placed in the custody of an entity or individual appointed by the court. So in other words, when we go to court and say, "Judge, can you appoint this young person a guardian?" Right? If the judge says, "Yes, I'm granting guardianship," which is what we want, right? That counts as dependency. Okay, that's where we get that third finding of dependency. If the guardianship is granted, if the custody is granted, etc. Okay, I wrote down here just some other types of cases where you can have dependency. Okay, guardianship, custody. Article 10 is the abuse and neglect. Family offense is where one person is filing a petition for an order of protection in family court. Okay, so that kind of case, adoption, not child support. That's excluded. I have juvenile delinquency here, even though there's bad case law on that, but I think the case law is wrong. So I declined as my small form of protest to remove it from my slide. All right. Okay, yeah. Reunification with one or both parents is not viable due to abuse, neglect, or abandonment. So again, as I said before, it's if the young person's living with one parent, maybe that parent's even going to be their guardian, their sole guardian, that's okay. You only need to find non-viability of reunification with one parent. Um, it's pretty well established now, not just in New York, but elsewhere as well. But there were some states that gave some pushback. So this is where, again, if you're doing your initial meeting with a young person, to have some sense of abuse, neglect, abandonment, I give you the Family Court Act section here. It's 1012. 1012E defines abuse. 1012F defines neglect. But case law, fleshes that out a lot more. It's not something that you need to delve into deeply just to sort of get a sense of eligibility. But I did give you a list of common forms of abuse and neglect that we hear about from our clients. The excessive corporal punishment, which, by the way, obviously has so much cultural dynamic there. um, under New York law, which is a little more strict than many of the cultures we might have come from in terms of what constitutes excessive, which, by the way, just goes to, again, the questioning of a client. Like if you say, did your parents ever punish you too harshly? The harsh to our client might be very different from what we're picturing. So sort of determining facts. When you got in trouble, what did your parents do? Rather than putting an adjective or an adverb on it. Was it, did they punish you in a harsh way, etc. Determining facts can help. Perpetuating domestic violence. So if a parent perpetuates domestic violence in front of our client, that can constitute neglect. That's another one that's actually not in the statute, but case law fleshed that out. Educational neglect, inadequate supervision. Is the child being left alone? Was the child left alone all the time? Physical abuse is like a level up from excessive corporal punishment. That's where there's permanent injury, there's scarring, there's danger of death or permanent disfigurement. sexual abuse goes from anything from extreme sexual assault to other definitions that you would see in the criminal law. It refers to the criminal law. Unwanted touching, things like that are all part of that. Lack of contact, so that's sort of the abandonment. If there's a lack of contact for 6 months or more, that constitutes abandonment. And a general lack of financial and emotional support can also go to abandonment as well. So I wrote etc. here very intentionally. Like this is just some of the ones that you might see that are the kinds of things that could make your client eligible for this finding, the reunification not viable to abuse, neglect, abandonment. Similar basis under state law. I know that Trump's USCIS is going to push back on this, but death of a parent can be considered a similar basis. So if you are interviewing someone and they're living and both their parents are deceased, or they're living with one parent but the other parent was deceased, if this is their only or their best shot at immigration relief, 100% worth it. We've gotten plenty of SIJS findings and granted I-360s based on that. I think this administration is going to, if they notice it, is going to try and push back on it. But there's decent case law to use for it. So if that's the only thing that's available, do it. If you do have one of those cases, definitely talk with a lawyer who does one of these, because there's certain ways that you want those findings from the court worded, so to make sure it works. Okay. And then lastly, not in the best interest to return to the child's home country. Yeah, these are, anything you can show things are more stable here. The client has attachments here. Their welfare and happiness is better off here. It's very dangerous in their home environment, in the country they came from. There's violence in their home environment. All of the kinds of things. And the reason this is sometimes a little easier is because you can very easily start out with, why did you come to the United States? You might hear from your clients, well, I came here because I wanted to have, better work opportunities and education opportunities. Okay, that's a good start. And that can go to this. And then you can sort of, you have to sort of dig a little bit deeper. Like, what were the conditions like where you were living? Who were you living with there, etc. So to get this sense, what you're basically doing in this last finding is showing this young person is better off here than in the country that they came from. Okay, and there's a lot of flexibility in terms of how to show that. Okay. Oh yeah, this GF42. Yeah, so that's a form that's on the Unified Court System website, that gives you a sense of what a special findings order looks like. I'm going to stop the share here because I want to show you guys what that looks like. Okay. So hang on, I want to try and move. Yeah, you guys can see that, right? Okay, good. So it's a bit gobbledygooky, right? And we lawyers, for some reason, love making things really difficult to work with. But it does give you at least, and I would not advise using this form, but it is a good form as a guide so that you understand what you should do. So for example, in this first part, it says, this court, after examining the motion papers supporting, is it affirmations or an affidavit, right, etc. Take out the one that it's not really and just say supporting affidavit, etc. And here, take out the boxes you don't need, but you can see it goes through each of them, right? It says the above named child is under 21 and unmarried. The child is dependent on the family court. Reunification is not viable due to abuse, neglect, or abandonment, and it's not in the best interest to return. So it's a good guide, but again, I would not advise sort of using that. Okay, let me go back to my PowerPoint. And I'm probably going to stop in about 10 minutes, however far I've gone, just to open it up to some questions and stuff. All right. SIJS 42. Yeah. So just like a little bit of a reminder of what those special findings allow the young person to do, and also some consequences down the road. So one, remember, these special findings orders, it allows the young person to apply for SIJ with USCIS. It doesn't guarantee a green card. Even if they get special immigrant juvenile status, it doesn't guarantee a green card and lawful permanent residence. But it's a pretty good indicator. Usually, if a young person doesn't end up getting lawful permanent residence, it's because of an arrest history, you know, a more serious arrest history, or I mean, that's usually the main reason when it isn't granted down the road. Um, this is not considered a conviction against a parent for immigration purposes. It's really important because sometimes a parent might still have some involvement with the kid, and really either the child or the parent who's still involved might be concerned, understandably, is this going to hurt my immigration chances? So the 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 answer is not that we have ever seen. Okay. Is it possible that it could? Yes, but it would take a lot of work by the government, right? They would have to go ahead and somehow dig up this application, match up the name, create, it would be really difficult for them to do it and then decide that they wanted to do something with it. But it's really, it's extremely unlikely that that would happen, and that even that they could use it as a negative factor. The flip side of that, it does not provide an immigration benefit um, to the parent or guardian. So um, if the young person gets SIJ and then gets a green card and then becomes a citizen, if all of that happened through SIJ, they will never be able to help their parent get lawful status. They will not be able to file a family petition for them, okay? Or any other kind of benefit for the parent. So why is that important? That's important if you're working with a young person who qualifies for other type of relief also, asylum or a trafficking visa or a U visa, which is if they were a victim of crime. Um, if they're eligible for those things, then you need to have a conversation, or the lawyer needs to have a conversation with them about, you have multiple forms of relief here. This one, SIJ may be more straightforward, but this one, say asylum, a little more challenging. But if you get lawful status through that, you will be able to one day apply for a parent. So that's something, that should be discussed in those cases. And by the way, you can get SIJ status, and then you have SIJ status, and then, but let's say then you also get asylum, or you also have an opportunity through one of those other visas. You can give them a benefit through that other method. Okay. Yeah, some of the challenges of these, I talked about a couple of these, but you're asking for young people to talk about often the most traumatic events in their lives, abuse or neglect they experienced, what led them to come to this country, those kinds of things. Sometimes there are interpreting difficulties. Uh, all of the service requirements that I mentioned briefly can be a little more difficult in these kind of situations. Just some of the challenges I'm here to be aware of. I think I mentioned most of those already. One thing to remember are they're going to be working with interpreters in court. So to the extent that you may be fluent in a language that your client is, that's wonderful. If you're involved in preparing them for a court, make sure you work with an interpreter to prepare them, because that's what they'll have in court. I'm going to stop there because the rest of this is some case law that may be helpful, and I'm happy to come back to it if we have time. But why don't I take a break and answer questions that are out there, and if we have time, I'll go back to some of the um, some of the case law that's good. Okay, I see that you put it in there. Yeah,
Yeah, I've compiled some of the questions that people asked.
terrific.
You've alluded to some of these themes before, but I don't know if they were directly there's
Yeah, no, I'm
some ones.
happy if there's still a question about them after I thought I explained it, then I didn't do a good enough job. So I'll just go down the list that Alan has here. And Alan, if a new list gets started, that's fine. I'll just work from this one. So questions, guardianship. Do they have to be living with someone who can be the guardian, or can you show the relationship even if they're not living with them? Excellent question. Yeah. So um, the short answer is they don't have to live with the proposed guardian. Okay. The standard for having someone appointed as a guardian is it in the best interests of the young person? Okay. Now, the obligations of the guardian or the rights and responsibilities they have are to to make decisions about the custody of the young person. That doesn't mean the young person has to live with them. To make decisions about education, about medical care, and to be there to support them financially if necessary. That's broadly speaking. So they do not have to be living together. That said, you can anticipate in court that a judge is likely to be a little more skeptical about a case where you're asking for a guardian to be appointed and the young person doesn't live with them. So you'll want to be thoughtful about what are the things that show that this person is really the caretaker. It's the person for this young person, etc. And that can be all sorts of things. They give me advice whenever I need it. They make sure I'm going to school. Whatever it is, that can be helpful. Okay. If a parent is concerned about being apprehended and deported by ICE, what forms can be used to arrange? Oh, there's a great form. So I'm assuming this means like when a parent is with the child and the parent is worried what's going to happen if ICE comes and detains me. Are they just going to put my kid in foster care? What's going to happen? Great question. So there's a form which doesn't require you to go to court. It's called I don't know, Alan, if you want to, I guess I can put it in the chat, but it's OCFS 4940. And I'm going to give you the exact name of it here. I know it off the top of my head. It's a parental interest directive. Here we go. Yeah. Designation of person in parental relationship, OCFS 4940. And it's a great form because it can be used to basically say, upon this event happening, this person is going to be given the authority to have custody and make educational and medical decisions for my child. And the signers have to be the person who's creating that, as well as the person who's going to be the caretaker. And they have to do that in front of a notary, but no court involvement is required. And you can say in there, the parent can say, if I'm detained, then I want this person to become the custodian until I'm released. So those things are in there so you can sort of tailor it to needs. But again, it's an OCFS 4940. And where we do that with, since Trump, we've been doing that with a lot of our clients' families who are anxious about that. Great question. There is a standby guardianship form, but I wouldn't use that. It requires going to court and going through this whole mess just to have someone as a standby guardian when you can do that without it with this form. The OCFS Form 399 sounds a lot like a statewide central register form, which does not require specific addresses for people living outside the U.S. Is that true here too? Sadly, no. So in other words, the question basically saying is that the form that I talked about where you have to do the addresses for the past 28 years for anyone 18 or over, and they do check the state central registry to see if there's abuse or neglect history. The question was, well, what if they were living outside the country? Do those addresses need to be included? Yes, they do, which is idiotic because, of course, they do not go and check the records in those countries. That does not happen. And yet they require it. So you do have to put those addresses in. And that can get a little tricky because often addresses in the countries our clients come from are very different from they don't fit into the neat little boxes that this form has. And so you just have to do your best. The court mails the completed OCFS form, correct? That is correct. We submit the OCFS. Again, this is the form for the State Central Registry, Child Abuse and Neglect. So we submit that form when the guardianship is filed, but the court will send that to the State Central Registry, and the State Central Registry will send the results back to the court. So the only way for us to know about anything on there prior to court is if our client or the client's family tells us. Okay. Eligibility. If a client lives in what meets definition of common law marriage, can they claim they are not married? Yes. Yeah. A common law marriage where absolutely they can say they're not married. Does the court accept a client claim of abuse or neglect without any other evidence of the same? Yeah. Yes. Yeah. So in terms of evidence that's presented for these things, sort of best practices is going to be to have an affidavit from your client if they're able to, articulate and understand what's in an affidavit. Most of the time, we will also have an affidavit from the proposed guardian. And they should be ready to testify to those things. But if a client testifies credibly that, yes, they probably wouldn't say I was neglected, right? That's the lawyer to argue that. But they might say, the last time I saw my father, I was 3 years old. I'm 13 now. I haven't gotten any letters from him since then or any phone calls. He's never sent me any gifts. And no, he doesn't contact me on social media. That's abandonment. Okay. And just the testimony from the client is sufficient. Some judges sort of take it upon themselves to do a little bit of a light cross-examination because there's hardly ever opposing parties in family court to these kinds of cases. So they might ask some questions. And not to get too deep into the weeds, but one thing when you're preparing a client to testify is you want to think about the questions you are most worried about them being asked. And ask your client and see how they do with the answer. And you obviously can't coach them to lie in any way, but you can start to get ready so that when they give an answer, you're ready with a follow-up question that will clarify. Well, judge asks, well, have you had any contact with your father in the past, since you've been here for the past 6 months? Well, yeah, we did have 2 phone calls. Oh, well, I'm kind of worried that the judge is going to ask that. All right. Well, on those phone calls, who called who? Well, I called him because I was still trying to reach out to them. And what happened when you called? He hung up on me. Oh, okay. So it's not so bad. If that's true, right? Obviously, you can't tell your client to say that if it's not true, but it can help you understand how to work with those things. Okay. I understand the I-360 form needs to be filed with USS before they're 21. My question is it okay to be filed before 21, but the court date would not happen until after they turn 21? In other words, is it okay to have the I-360 form sent in a week before they turn 21? So you can't send that I-360 in without the special findings from the family court. That has to be a part of the packet. So if you sent in the I-360 and it didn't have that, in other words, if you didn't have a court date yet to get that, it would get rejected. So that's part one of the question. Is it okay to have the I-360 form sent in a week before they turn 21? Yeah. You could if USCIS receives that I-360 a day before the young person turns 21, that's sufficient. Obviously, we don't want to play with those kinds of deadlines, if at all possible, because, who knows what happens in the mail or whatever. We always send it FedEx so that we have proof that it got there, but which is what I'd recommend. But yeah, you can send it in as long as it's received by USCIS before the young person's 21, you're okay. But you have to have that order in it. So you can't wait. You can't send it in and say, oh, and we'll send you the special findings order later. That doesn't work. I hope that answered that question. The children whose parents are deported and the child is left behind, do these children have a colorable abandonment claim for SIJS findings? So maybe. So the question is basically, let's say there's a young person here and both their parents get deported. Can they say, hey, I'm eligible for SIJ because reunification isn't viable due to abuse, neglect, abandonment, or a similar basis? I mean, so if there's no contact for 6 months or more equals abandonment, lack of financial and emotional support equals abandonment. So it would depend a little bit on the nature of things here. But if they're deported, but you know, the child is talking to the parents every day and they're still supporting, you know, they're still there for them, and it's a little harder to make that argument. You could try and make an argument that it's something similar, right? A similar basis. But you'd have to convince both the family court and then even more difficult, you'd have to convince USCIS that that's a valid basis for non-viability of reunification. So it would depend a little on the facts whether that could work. Do mandated reporters have to report abuse and neglect to ACS or CPS? So if you're a psychologist, a social worker, a teacher, a police officer, a district attorney, no other kind of lawyer, but a district attorney, you're a mandated reporter. So if you hear about a child who has been abused or neglected, you do have to call in the report. But I'm just going to get my statute book, which is right back there. First of all, if you're seeing them outside of your context as a social worker, you might not have to. And by the way, for those of you who are wondering, this is in the social services law, 411, I believe. Don't you guys love legal research on the fly here? It's great. Shall receive. Mandated reporters. Taking oath, reporting. Sorry, here we go. Persons who have the following persons are required to report when they have reasonable cause to suspect that a child coming before them in their professional or official capacity is an abused or maltreated child. So if they're coming and if you're one of those mandated reporters, and the child is coming before you in your professional capacity, see, there's a little wiggle room there potentially, right? Then you do have to call it in. Okay, but otherwise you don't have to. If you are going to be a mandated reporter, you probably want to think, I mean, if you are a mandated reporter and this is part of your professional capacity, you probably want to think about, you know, at what point you want to be involved in doing the interviews, because the young people coming may not want a case called in, against their parent. So you'd have to think about that. But remember, it's in your professional capacity. So are you working through New Sanctuary as a social worker or as a volunteer who's helping out? Are you there as a police officer, as a teacher? Probably not. So you wouldn't be required to call it in. Okay. Oh, good. Thanks for putting that in there, Alan, the OCFS 4940. All right. If someone has been married in another country, but that marriage is not recognized in the U.S., would they likely be considered married for the purposes of SIJ application? Okay. So no, if that marriage is not recognized in the U.S., but you would need to show that, which is doable. So, there obviously there are marriage laws here in the U.S. that in surprisingly not all states, but New York and many states that indicate that you can't be legally married at a certain age, and so you would make that point when saying that they're unmarried. Yeah, good question. Okay. Oh, yes, that answered the question. Okay, good, Wendy. I'm glad. Um, if a judge takes a child out of asylum proceedings and the mom or dad win asylum, can the child get back into that case? So for an immigration judge, right? If um, mother, father, and child are all in asylum, or the child is what's called a derivative, right? For asylum, and the case gets separated out. So that the child then can pursue other types of relief. Can they consolidate the cases? Yeah, you could try and get the judge to consolidate the cases back, but I think that would be tricky, especially post the asylum being granted, because you'd have to kind of recalendar the case, and then say, hey, we need to join this child up. I can't imagine a judge going along with that as something to do. But that said, there is no harm in the child continuing to ride along with the parent's asylum case. In fact, it can be very helpful. Um, so, but that's going to be sort of a case-by-case question. Jill asked, just to clarify, a child can apply for multiple forms of relief at the same time, correct? Yes. So they can apply for SIJ and appear as a derivative on someone's I-589, correct. That is correct. All right. So adapted forms can be filed for family court. Does not have to be the forms listed in your court, so long as the custom forms contain the same info. Right, because I said like, hey, we don't use the forms for guardianship that are on there. So yes, for most of those forms, you can adapt them. The only one that I would really do that for is the petition itself. Because the other ones are like one page, just use their form. Um, and you can't do that for the OCFS form that goes to the state central registry. That has to use that form to do that. And obviously, in case it's not clear, don't try using your own forms for any immigration application. You have to use for the SIJ, it's an I-360. For lawful permanent residence, it's an I-485. A work permit's an I-765. You must use those forms that they have on their website, and you must use the most updated version, or it will be rejected. But for family court, I wouldn't mess around with the forms except for the guardianship one. And again, if you're going to do that, have a lawyer who's done a lot of guardianships look at your modified version to make sure it's all copacetic. Yeah, Cheryl, thanks for putting that in there. I didn't want to go down that little bit of rabbit hole, but it's a great point that if you are a social worker who works with a legal services organization, um, uh, some of those legal services organizations and the social workers who work there take the position that they're not mandated reporters. Okay, so in other words, as Cheryl knows, obviously, because she put it in here, if she were interviewing a young person at the legal services organization where she works, and there was a disclosure of abuse or neglect, even though she's a social worker, she would not be compelled to report that. She would not be a mandated reporter. Just be aware that there are some agencies that have legal services organizations like Lawyers for Children in New York City that take the opposite view, that actually the social workers still are mandated reporters. Just to sort of keep in mind. But yeah, good. That was the last question I had. Are there no more in the pike, Alan?
No, not that I could see.
All right. Let me, I promise, even though I'm going to talk about case law, some of it will relate to some of the stuff that you'll likely be doing in terms of getting these applications out there. So I'm going to go back to my PowerPoint. Oh no, it's this one, I think. Yeah. Okay. So, yeah. Oops. There. Okay, can you guys see that? Is it shared? Yeah. Okay, good. Yeah. So this is something that sometimes comes up. Like, the proposed guardian might say, I don't have lawful status here. Can I be a guardian? Answer, yes. Um, and there was a case where the family court judge was trying to deny guardianship because the proposed guardian did not have lawful immigration status, and the appellate court smacked it down and said, no, 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 that you do not have to show that you have legal status in order to be able to be appointed as a guardian. So it's just good to remember because that is likely a scenario that you'll see. This is just saying what I said. I'm not going to go through all these cases, but basically the idea is that a parent can be appointed as a guardian. There was pushback on this at first from the family court judges. They said, well, it's a parent, they already have guardianship. So why would I grant guardianship now? And the answer to that is that family court judges do that all the time in custody cases. They'll appoint, the parent who has custody as the sole custodian because the other parent is problematic. And so it's the same thing with guardianships, but it took a while for judges to wrap their heads around it. If I'm being uncharitable, it's because of xenophobia. If I'm being charitable, it's because it was a new type of case that was being brought to show this. I won't tell you which I was at the time, but we did appeal it and get it overturned. All right. Certified copies. I don't worry too much about this one. It's just that, some of the courts say we need a certified copy of the birth certificate. And in fact, this case is saying like, no, you do not need to get certified copies. It's better if you do have one of the birth certificate is the document we deal with most, better to do it, but it's not the end of the world if your client doesn't have a certified copy, but just sort of like a picture that they took of their birth certificate. Service, I won't bore you with that one. Oh yeah, this is so right. I told you guys that like dismissing the case because the guardian didn't get fingerprinted is reversible error. So there's a case too, which I don't usually mention, but that those OCFS checks, that's the check at the state central registry for abuse and neglect, right? That those aren't legally required as well, that you don't need to submit them in guardianship of the person cases, which are the kinds we do. So I love that this case is out there because I use it sometimes, especially if I have a client who's going to age out pretty soon. But the decision is wrong. they they cite to a provision, and sorry to get into the weeds here, everyone, but they cite to a provision of the law that doesn't say anything about these OCFS checks, but there's another provision that they somehow forgot about that does require it. So, and most courts are going to require it, but this is good to use if you have a client who's come in and they're turning 21 in a month. And usually these OCFS checks take 6 to 8 weeks or longer sometimes. This is a great case to use, if you're in court saying, Judge, the second department has been clear that these OCFS background checks aren't necessary for these cases. So I'm asking you to proceed. So it's useful in that way. Oh gosh. Yeah. I don't like this case. This is one that said that the young person has to be living in New York for 6 months prior to commencing the guardianship case. Sometimes our clients, have not been here for 6 months, but they're turning 21 soon. And so there's some urgent issues here. If that happens in any cases, talk to someone. You can talk to me if you want. There are some issues mentioned in the brackets there that might allow you to still get the case in. And frankly, most judges don't even really pay that much attention to this, but some do, and you have to be ready. Yeah, if it's an unknown father, that's fine, but you might need to use special language. Usually this happens in particularly tragic circumstances where, our client's mother was, raped and by a stranger, or in the worst, situations was gang raped, and that no one knows who the father is. Obviously, that young person should still be eligible for SIJ, that you would not want that to make them ineligible. So there is language that you can use in your order that USCIS has accepted. And so if you have a situation like that, again, I would talk to someone about some good language to use, but there's good case law on it as well. Where are we at? All right, good. Yeah, other types of relief. So again, this is on the PowerPoint I gave you, that if you go to the link at the bottom there, it gives you like 4 or 5 questions to ask to sort of get a very basic idea is, oh, might this young person be eligible for some of these other types of relief that you know, not infrequently our clients are eligible for. I do want to point out just a couple of things. Asylum, especially with this administration, is getting more and more difficult. U visas, victim of certain serious crimes, there's a huge wait list, like 20 years, but you can get a work permit in the meantime. And also the crime has to happen in the United States. T visas, blah, yeah. Yeah, family-based children, yeah, including children adopted. So if you're talking with someone and one of their parents, it's unusual, but is a lawful permanent resident or a United States citizen, you know, that's a much better way to go, if you can, because they'll be eligible for sort of immediate family-based visa, and same with marriage. But there are definitely certain barriers to that, so you'd want to talk to an immigration lawyer to make sure that either of those were viable. All right, and I think that's it. Yeah. Additional questions? Let me just see. No, I think we're good. Ravi or Alan, anything else you want me to talk? I got another 5 minutes
I
here.
do think there were a couple additional questions.
Oh, there were?
Claudia and Anita.
Oh, thank you. Good. Hadn't seen those. Thank you very much. What about certified translations for birth certificates? Do judges follow the strict CPLR requirements? So, yeah, the case law now says that there is no express requirement to have a certified translation. But it's still in the CPLR. So my advice is to get a certified translation of the birth certificate. It shouldn't be that hard, especially in New York City, to get someone who can translate it. And by the way, certified translation, just to be clear, that means having the person who translate it sign an affidavit that says, I'm fluent in this language in English, and I translated this accurately, word for word. I mean, I'm paraphrasing a little bit, but that's it. It's a short paragraph that they have to sign and have notarized. So that's something it's good to have just sort of a template form for, and you can just substitute in the name of the interpreter and the name of the child and put it in there. So I would still do that for the birth certificate. It's easy enough to do. Okay, wait, there's more here. Yeah. Does the court appoint an attorney for the child? Anita, thank you for asking that question. Yes. The court will definitely appoint an AFC, attorney for the child, on these cases. And sometimes you will get amazing AFCs who are fully familiar with these. And if you talk to that AFC, which is what I would suggest, right, and say, hey, you know, we're the one who helped them file this. This is a young person who's eligible for SIJ. Will be like, take it and run with it and know exactly what to do. And you will get AFCs who will be like, yeah, I don't do SIJ. Which, by the way, they're ethically required to get those findings if they have a client who's eligible. But you'll still get AFCs who will say no. So, but you will have an AFC appointed. And I would say the vast majority either know how to do it and like doing it, or are very open to having, for example, someone from New Sanctuary saying, "Hey, we've been working with this young person and their family, and because they're SIJ eligible, and very open to working with you to get those findings." There are a couple who are jerks, but that's true everywhere. So, all right. If we're working with asylum seekers with children, any advice about where we can send them for SIJ guides, and if it seems like the child might be SIJ eligible? Yeah, it's tough with the funding stuff now, but in the city, Safe Passage is great. The Legal Aid Society has an immigration unit that focuses on children. Um, uh, Make the Road New York is terrific. Um, I'm trying to think, Robbie. I don't know if you know others off the top of your head, but there's a bunch that are out there. The challenge now is that oh, and there's Kind also, which sort of organizes the private bar to do that. But a lot of them have these cuts in funding that make it much more challenging now, which I think is part of why Robbie was like, "Uh-oh, we better do another one of these."
Yeah, the DOE, CWS, they have been trying to build something up, but no funding has been cut. So I don't know what is going to happen with this.
Yeah. Uh, Question about has to be notarized. Yeah, the affidavit for the translator. So um, any of these things that you're submitting as affidavits, I would get them notarized, even though there's a pretty recent New York law that says, hey, affirmations are now as good as affidavits in the vast majority of cases, which means that if someone signs a document saying, I swear this is true, and then signs it, you don't need to get the notary to stamp it anymore. But I would still err on the side of caution if, as long as it's not overly cumbersome, and have it notarized just to be safe. Yeah. Good. And that brings us right to 12:30. Um, Anything else, Robbie, in closing, to say, or that I should say, or
Well, what I would want to say is again, reiterate, we would hope or we will guide people to find lawyers because we do need to have uh, them represented and keeping a record properly. But you will find that many have access or will be unable to afford those representations. So this is where we need to be filling that space. Um, this is awesome. You know, you timed it properly. We never get this on this on the dot. What we also would like to ask you, Theo, is in the last trainings we had with you, you actually went through the paperwork, the documents, and those those questions and why it's important to answer those questions. We're not going to do that today, but I would want to be talking with you about working with to make that happen again. And
absolutely.
this is all recorded, so we should have a recording of this. And we will figure out how to post the stuff. Maybe it's on the website. Um, and all the documents will be sent to everyone who signed up. Any,
Yeah.
Alan, you have anything else to add?
Well, definitely want to give a really huge thank you to Professor Theo Liebmann. Amazing job today. Yeah, but there's an applause reaction. But we really appreciate your time. All you folks out there, this is dense material, but it has very human consequences. And if it felt like it was a lot, or it was above your head, or if you're wondering, you know, still get in touch with us, newsanctuarynsc.org. At their Get Involved section, we need help at all levels of expertise. Um, if helping our folks in the courts and outside of the courts interests you, if you fill in that Get Involved form and make sure to opt into emails. It's not an obligatory thing. It just means that we have your contact information. We know what kind of languages you speak and anything you can offer to help. Yeah, so thank you all for being here. Um, and that's really
I
all
ju-
I had to say. Thank you very much.
yeah, I just wanted to add, our role is not just about providing services, which is filling out these forms. That we leave that for the lawyer. What we want to do, I'm making a joke to you. Um, we want to change the process, the system. So, when if we filing something in court, we're just not going to let the child or the attorney, the court appointed attorney to handle it. We are going to be accompanying the people through this process, both the child, the guardian, at family court and at immigration, so that the system starts to be a little more merciful, more respectful, and that we, especially in this administration, we need to show that we are there. And sign up. We have had to rethink and we have to rebuild the structure of our process. So we will need a lot of help, and we meet us on Thursday nights at the Brooklyn Quaker House at 110 Skimmerhorn Street from 5:30 to 7:30 to start working out the details of how we can make this a very effective uh, process to help the kids, but also stop this administration. Theo, any last words from you? Thank you very much. I appreciate it. You have always been a valuable ally, and I'm glad we could count on you, and we will be reaching out to you as we continue to challenge what is happening.
Excellent. I look forward to it. Thanks for having me.
Thank you.
I'll send you the
Okay.
recording.
Thank
All
you.
right.
Have a good night. Good day, everyone.
Bye-bye.
Everybody.